Trump just made what legal experts are calling the most serious mistake of his legal career. In his New York civil fraud case, a federal judge has formally referred him for criminal contempt after a courtroom exchange that sources describe as catastrophic. This is not political rhetoric, and it's not partisan spin. This is a sitting federal judge, on the record, declaring that the conduct of a former president may have crossed into criminal territory. When a judge starts using language like willful defiance and deliberate obstruction in open court, it signals that something extraordinary has happened. These are not words judges use lightly, especially when the defendant is a former president of the United States. What triggered this unprecedented move wasn't a speech or a social media post. It happened inside a federal courtroom during what was supposed to be a routine pretrial hearing on January 15th. According to multiple sources present, Trump allegedly refused a direct judicial order to produce financial documents and then launched into a personal attack on the judge's integrity that stunned even seasoned courtroom observers. This was not just another heated legal moment. Members of Trump's own defense team were reportedly left questioning whether continued representation was even possible. And when your own attorneys start reconsidering their position, that's not a warning sign. That's a crisis. Tensions inside the Manhattan federal courthouse had been building for months. Discovery disputes, missed deadlines, and increasingly hostile exchanges between Trump's legal team and the presiding judge had already pushed the case to a breaking point. But everything escalated on January 15th when the court reconvened for what was scheduled as a simple status conference on document production. The hearing was set for 9:30 a.m. By 10:47 a.m., less than 80 minutes later, Judge Arthur Brennan had issued a formal criminal contempt referral to the United States Attorney's Office for the Southern District of New York. 77 minutes. That's all it took to go from a routine conference to a criminal referral against a former president. The issue centered on a subpoenaed set of financial records from the Trump Organization covering the years 2018 through 2022. Documents the judge had ordered produced not once, not twice, but 3 separate times over a 4-month period. When defense counsel admitted in open court that the documents still had not been turned over, Judge Brennan demanded an explanation directly from Trump himself. This is where everything shifted from procedural to personal. When Judge Brennan asked Trump directly why he had failed to comply with 3 separate court orders, the response stunned the room. Against the explicit advice of his attorneys, Trump reportedly stood and addressed the judge himself. He claimed he had complied with everything that was reasonable and argued that the documents did not exist in the way the court believed they did. The judge's response was immediate and firm. Trump was instructed to address the court through counsel and to answer the question asked, not the one he preferred to answer. But according to multiple witnesses, Trump did not back down. His voice rose. He dismissed the proceedings as a sham and framed the document requests as an attack on his business success. And that moment marked the point of no return. What happened next is what veteran court reporters described as the turning point. After Trump's second unprompted outburst, Judge Brennan called a recess. 15 minutes. That pause would end up defining the rest of the case. According to sources familiar with the proceedings, Trump's lead attorney was seen in a heated discussion with his client inside a side conference room during that recess. Court security personnel reported raised voices coming through the closed door. This was not strategic planning. It was damage control. When court resumed, Trump's attorney attempted to regain control. He apologized to the court on behalf of his client and requested a brief continuance, promising that the remaining documents would be produced. The judge denied the request without hesitation. What followed was described by multiple observers as one of the most dramatic judicial confrontations they had ever witnessed. Judge Brennan then addressed Trump directly, reading from what appeared to be prepared remarks. He stated that after 3 separate orders to produce documents, after explicit warnings about the consequences of noncompliance, and after the conduct displayed in court that morning, the court had no choice but to conclude that the respondent had engaged in willful contempt. This was no longer about missed paperwork. This was about authority. The courtroom fell silent when the judge announced he was making a formal criminal contempt referral. Reporters present said Trump's expression visibly changed. His hands dropped. His posture stiffened. His attorney immediately rose to object, but the judge cut him off. The judge stated plainly that Trump had been given every opportunity to comply, every opportunity, and that the time for objections had passed. Then came the language that shifted this case into unprecedented territory. Judge Brennan read the referral directly into the record, stating that Donald J. Trump was being referred to the United States Attorney for the Southern District of New York for criminal prosecution under federal contempt statutes, including potential obstruction of justice charges. The court's finding was that the conduct demonstrated a pattern of deliberate defiance of lawful court orders that could not be addressed through civil sanctions alone. That phrase matters, cannot be addressed through civil sanctions alone. In legal terms, the judge was saying fines were no longer sufficient, warnings were no longer effective. Only criminal prosecution could restore the authority of the court. This wasn't a political decision, and that distinction is critical. Judge Brennan was appointed decades ago and has a long record of measured nonpartisan rulings. When a judge with that background makes a criminal contempt referral against a former president, it signals that the behavior crossed a line that the court could no longer tolerate. At that moment, this case stopped being just another legal battle. It became a test of whether court orders still carry weight when the defendant is powerful enough to ignore them, and that question was now out of Trump's hands. At this point, legal analysts began drawing historical comparisons, not because the circumstances were identical, but because the pattern felt familiar. Obstruction, escalation, and then consequences that could no longer be controlled. The closest parallel many experts pointed to was Richard Nixon. During the Watergate era, Nixon ordered the firing of Special Prosecutor Archibald Cox to prevent the release of subpoenaed White House tapes. Nixon himself was never held in contempt, but the public backlash was so severe that it accelerated the collapse of his presidency. The lesson was simple then, and it remains the same now. When defiance meets institutional authority, the outcome is rarely favorable for the person resisting. Another comparison often raised is Bill Clinton. In 1999, Clinton was held in civil contempt for false testimony in the Paula Jones case. He was fined and temporarily suspended from practicing law, but that contempt was civil, not criminal. The distinction matters. Criminal contempt is fundamentally different. It carries potential imprisonment. It is punitive, not corrective, and it is exceptionally rare, especially against high-profile defendants. That rarity is exactly why Judge Brennan's referral is being taken so seriously across the legal community. This referral also does not exist in isolation. Trump has a documented history of testing court boundaries. In a separate New York civil fraud case, another judge previously fined him for violating a gag order, then doubled the fines when the behavior continued. The pattern has been consistent. Court orders are treated as suggestions. Warnings are met with escalation. What changed here is that the court finally stopped escalating penalties and instead escalated accountability. According to filings reviewed by legal experts, prosecutors later revealed that some documents Trump claimed did not exist were in fact discovered on Trump Organization servers by a court-appointed special master. That revelation transformed the case. This was no longer about failure to comply. According to the judge's findings, it became about deliberate concealment paired with false representations to the court, and that combination dramatically increases criminal exposure. The documents that were discovered reportedly contained internal property valuations that directly contradicted sworn statements Trump had made in earlier proceedings. In at least one case, the difference between internal valuations and public representations exceeded hundreds of millions of dollars. When documents are claimed not to exist, then later found, and those documents contradict sworn testimony, the legal consequences multiply. At that point, prosecutors are no longer dealing with noncompliance. They are dealing with intent. And intent is what turns procedural violations into criminal cases. This is why legal experts say the referral represents a tipping point. Not just for this case, but for every other courtroom Trump walks into. Judges in other jurisdictions are now watching closely. Behavior that might once have been tolerated will no longer be viewed in isolation. The message has been sent. Court orders are not optional, and the system is now being forced to decide whether it will enforce that principle, even when the defendant is powerful enough to challenge it. As news of the criminal contempt referral spread, the political consequences began to surface almost immediately. This was no longer confined to a courtroom in Manhattan. It was now a national issue with implications far beyond the legal system. Republican leadership found itself in an extraordinarily difficult position. On one side, there is intense pressure from a base that views any legal action against Trump as persecution, regardless of the evidence. That pressure demands full-throated defense, attacks on the judge, and claims that the justice system itself has been weaponized. On the other side, there is the reality of a federal judge's written findings that describe willful defiance, concealment of documents, and false representations to the court. Republican leaders now have to explain why behavior that would land any other defendant in serious trouble should be excused when the defendant is their preferred candidate. There is no comfortable middle ground here. Either the judge, a decades-long veteran appointed by a Republican president, is corrupt and lying on the record, or Trump did exactly what the referral says he did. Every attempt to thread the needle risks alienating one side or the other. Legal analysts have begun calling this a potential turning point. Former federal prosecutors point out that criminal contempt referrals against high-profile defendants are exceedingly rare because judges understand the gravity of such a move. The fact that this referral is detailed, written, and entered into the record suggests the judge anticipated intense scrutiny and wanted the strongest possible foundation. Even legal commentators who have historically defended strong executive authority have acknowledged the seriousness of the situation. Several have stated publicly that if documents were concealed after multiple court orders, the legal exposure is significant regardless of political perspective. This is no longer a question of ideology. It's a question of compliance with the rule of law. And then came Trump's response. Late on the night of January 15th, just hours after the referral, Trump posted a statement attacking the judge personally. He accused the court of political coordination, dismissed the missing documents as fabricated, and concluded with language that legal experts immediately flagged as potentially problematic. He warned that the judge would face consequences for his actions. That response raised immediate alarms. Instead of expressing any willingness to comply, any acknowledgement of the court's authority, or any attempt to de-escalate, Trump doubled down. Legal experts noted that such statements could be used as evidence of continuing contempt. When a defendant responds to a contempt referral by attacking the judge and promising consequences, it reinforces the court's findings rather than undermining them. This is where the situation becomes especially dangerous for Trump. Criminal contempt cases hinge on willfulness, intent, a conscious decision to defy judicial authority. Public statements that appear to threaten a sitting federal judge only strengthen the prosecution's argument. At this stage, the issue has grown beyond one referral, one judge, or one courtroom. It has become a test of whether judicial authority has any real power when confronted by political influence. If the system enforces its authority here, it sends a message that court orders apply to everyone. If it does not, it sends a very different message, one that future defendants will cite and future courts will struggle to overcome. The consequences of that choice will not be confined to this case. Whispers. They will ripple through every courtroom in the country. At this point, the legal process moves out of the judge's hands and into the hands of federal prosecutors. The United States Attorney's Office for the Southern District of New York now faces a decision that carries enormous weight. A criminal contempt referral does not guarantee prosecution, but it does require prosecutors to evaluate whether the evidence meets the standard for indictment. Legal experts say declining to act after such a detailed referral would require extraordinary justification, especially given the findings already entered into the record. The typical timeline for this kind of decision is 60 to 90 days. That places the next major development squarely in the weeks ahead. Prosecutors may convene a grand jury. They may request additional testimony, or they may decide the case is strong enough to proceed as is. The implications extend far beyond this single case. Trump is already facing criminal charges in multiple jurisdictions and civil judgments totaling hundreds of millions of dollars. A criminal contempt indictment would add a new dimension to those cases. Judges in other courts will be watching closely. Any behavior that resembles defiance will now be viewed through the lens of this referral. This changes the legal landscape.
There are political consequences as well. A presidential campaign unfolding alongside a criminal contempt case creates a unique and volatile situation. Every public appearance becomes a potential legal liability. Every statement is scrutinized not just by voters, but by prosecutors and judges evaluating intent and compliance. The image of a candidate attacking judges and defying court orders carries far more weight when those actions are already documented in a criminal referral. Beyond the immediate legal and political fallout lies a deeper issue. The courts are the institution Americans rely on to enforce the rule of law equally. Their authority rests on the principle that no individual, regardless of power or position, can simply ignore their orders. If a former president can repeatedly defy court orders, conceal documents, attack judges, and face no consequences, that principle erodes. Court rulings begin to look optional. Authority becomes conditional.
Size, and once that precedent is set, it cannot easily be reversed. This is why so many legal scholars are watching closely, not because of loyalty to one individual or party, but because of what this moment represents. A stress test of judicial authority itself. The referral has been made. The evidence is on the record. The decision now rests with prosecutors. Pause. And whatever happens next will shape how future courts, future defendants, and future presidents understand the limits of power. What happens next will determine far more than the outcome of a single case. If prosecutors move forward, it will mark the first time in modern history that a former president faces criminal prosecution specifically for defying a federal judge's authority. If they decline, it will raise an equally profound question: whether the courts can enforce their orders against someone powerful enough to ignore them. This is why the stakes are so high. Judicial authority depends on compliance. Courts do not have armies. They do not enforce rulings through force. Their power exists only if their orders are respected or punished when they are not. Every future defendant is watching this case. Every future judge is watching it too. Because if a former president can treat court orders as optional, then the meaning of those orders begins to change for everyone. Trump's supporters argue this is persecution. His critics argue it is accountability. But the legal system does not operate on belief. It operates on records, transcripts, and findings entered into the public record. And those records now describe willful defiance, concealment of documents, and conduct that a federal judge concluded could not be addressed through civil penalties alone. In the coming weeks, prosecutors will decide whether to convene a grand jury. Judges in Trump's other cases will decide how much tolerance remains. Political leaders will decide whether defending defiance is a risk worth taking.
But one thing is already clear. This is no longer just about Donald Trump. It is about whether court orders still mean what they say, whether judicial authority applies equally, whether power changes the rules or merely tests them. The referral has been made. The evidence has been entered. The response has been recorded. Now the system must answer a question it has spent generations avoiding. When power refuses to comply, does the law still hold? And whatever answer comes next will echo far beyond this case.